Hello and welcome to this podcast on the English and Welsh legal system with Ryan Murphy. Today we are going to explore the way in which international law obligations impact on the way in which the English legal system operates. We're going to use a very particular example. We're going to look at the case of the European Data Retention Directive. And although it's very unlikely that you will need in any study of the English and Welsh legal system to know the details of the European Data Retention Directive, it acts as a really good example of the multiple levels of influence that international law obligations can have on the domestic legal order, and in particular, how legal orders interact and intersect. So this particular podcast looks at the intersection of the English and Welsh legal system with the legal system of the European Union. So with that said, let's make a start. So a little bit of context may help you to understand what follows. We're talking about a directive that was passed in 2006 called the Data Retention Directive. As I say, it was passed in early in 2006, and its intention was to harmonize data retention practices across the member states. So all of the member states had different legal frameworks for dealing with the question of data retention. And so that's the obligation upon providers, internet providers, telephony providers, internet ISPs, to store data and give over that data to the authorities. And the European Union saw that this was problematic, that you had different practices in different member states. And so this directive was aimed to bring to the same level to establish a common legal framework for data retention practices, in particular for the purposes of the prevention, investigation, detection, and prosecution of criminal offences. And essentially what the directive did was gave the authorities, such as the police, with some judicial oversight, very wide-ranging powers of access to the data that had been stored with these providers. The providers had to give over this data to the authorities when so requested. This directive was hugely controversial. It's controversial with lots of NGOs and lobbying bodies who believed that this was a fundamental infringement of people's right to privacy. And so it was a controversial directive. It gave, as I say, very wide powers to the authorities in terms of accessing people's data. And the measure was challenged, and the challenge ended up before the European Court of Justice. So the Court of Justice of the European Union, in the joint cases 293/12 and 594/12, actually annulled the directive. So they said this directive, in an indiscriminate and general way, impinges and interferes with people's fundamental rights, including the right to privacy. And therefore, the directive was ruled to be unlawful by the European Union's own court. And so that's the context for where we are when we talk about this. You had a directive that was passed to harmonize data retention practices. That directive was later annulled, ruled unlawful, made a nullity by the European Union's own court. So let's see what the impact of all of this has on the English legal system and how the English legal system interacts, in particular with European Union law. But that's just an example of how the English legal system interacts with various of its international partners. So, what was the impact of the original directive? Well, the impact of the original directive was to create binding rules and a binding legal framework that the English legal system had to adhere to. And so directives are legislative instruments of the European Union, and they, at the time, created binding legal obligations on the United Kingdom as a member. Now, obviously, the United Kingdom has now left the European Union, or at the time of this recording was in the process of going through a transition period with the European Union. But eventually the time will come where EU law will no longer be binding on the English legal system. But at the time of this case, it was. And therefore, this directive created obligations for the UK to adhere to. The Digital Rights Island case didn't concern the United Kingdom. It's an Irish case. But the annulment of the directive annulled it for everybody. And so even a case that originated in another member state had an influence on the English legal system. So you have the original binding aspects of the directive that were annulled by the Digital Rights Island case, leaving something of a void in English law. So the UK had been obliged to adopt the principles of the directive. That directive is ruled to be unlawful. The UK is left with this gap in its framework for the retention of data. So what was the government's response? So the UK government's response was to use emergency procedure in Parliament to pass the Data Retention Investigatory Powers Act 2014 DRIP. So shortly after the judgment is handed down by the European Court of Justice in Digital Rights Island, the UK government has to act quickly to fill the void that's been left by the directive being annulled. And so they pass this piece of legislation. Now they do so at tremendous speed. And so what you might already know about the English legal system is that the parliamentary process can take some time. There's a whole process covered elsewhere that dictates how Acts of Parliament become Acts of Parliament, and they need to go through several stages that take place normally over months and potentially years. The Data Retention Investigatory Powers Act passed through Parliament within a matter of days. Very, very little parliamentary time was given over to consider this act. And this act essentially recreated aspects of the annulled directive and brought them into force in domestic law. Made some concessions to the concerns raised by the European Court of Justice in the Digital Rights Island case, but essentially the UK government took a strong stance. We needed the authority given to us by that directive, and if it's no longer possible to do that through European Union law, we, the government, will bring forward legislation through Parliament to reenact those powers. And I think really carefully about what the UK government is doing here, and think of whether it is appropriate, or under what circumstances is it appropriate for a government to act so rapidly when enacting legislation that has such a fundamental impact on people's freedom and rights, and then balance that against the competing argument, which is essentially that the government needs those powers in order to keep people in Britain safe. So it needs to be able to access this data to prevent terrorist activity, to interrupt organized criminals and organized crime. And so you see these sort of tensions arising in the lawmaking process, where on the one hand you have the rights of individuals to their privacy, and on the other hand you have the obligation on the state to keep its citizens safe. And think about how the English legal system facilitates those competing priorities, and which does it give precedent to when it allows really important legislation to be put through Parliament so quickly. Where does that balance lie? So that's where we get to in 2014. A European Union law piece of legislation gave powers to the UK. The directive was annulled. The UK replaces that directive with its own Act of Parliament. So now you have those powers are on a statutory footing in domestic English law. So how does the English legal system then deal with that tension? That something that was ruled to be unlawful in the European Union has now been brought into domestic law using the processes and mechanisms of the English legal system. So what essentially happened was some MPs got together and challenged the legality of the Data Retention Investigatory Powers Act 2014. Now, if you've studied anything of English law and of UK constitutional law, you will know that there is a very, very important principle of parliamentary sovereignty, that Parliament can make and unmake any law, and that the acts of Parliament are beyond challenge. So they can't rule, a court can't rule on an orthodox understanding of the constitutional arrangements for the UK and thereby England and Wales, can't rule an Act of Parliament to be unlawful or can't invalidate an Act of Parliament. So it gets to the High Court. The High Court come to the decision that this Data Retention Investigatory Powers Act of 2014 is still in breach of European law. That just because what was in the directive has now been brought to the domestic legal order doesn't stop EU law from being activated. And so what happens is, relying upon the Digital Rights Island case, the High Court suspend the main provisions of the Act. They say this Act is incompatible with EU law, and EU law requires us to suspend its application. We can't invalidate it because we don't have that power because of parliamentary sovereignty, but EU law has empowered English courts to suspend the application of an Act of Parliament. It comes from the Factortame case. And so you have this really, really odd situation. A measure that used to be European that was ruled unlawful becomes domestic law. That domestic law is challenged before the domestic courts of England and Wales, and the domestic courts of England and Wales, relying upon European law, suspend the application of that Act of Parliament. And you can start to see the sort of complexity of the interactions between the various legal systems, between those different jurisdictions. You can see that they don't just operate in silos completely distinct from each other. Each has an effect on the other one. And you'd be wise to remember that the law of England and Wales doesn't exist in a vacuum. So the High Court suspended the application. Eventually you get to the Court of Appeal, and the Court of Appeal make what we call a preliminary reference back to the Court of Justice, asking for an interpretation of the compatibility of the 2014 Act, the Digital Retention Investigatory Powers Act, with EU fundamental rights law. And you've got the case references there, case C203 of 15, 698 of 50. And so an English court, or a court in the legal system of England and Wales, the Court of Appeal, asks advice using a procedure within the European Union Treaties, Article 267, asks the European Court of Justice, the Court of Justice of the European Union, what do you think? Is an act of this nature compatible with fundamental rights in EU law? The Court of Justice say probably not, but it's for you to apply this. Comes back to the Court of Appeal, and the Court of Appeal uphold the High Court's finding of illegality. And so again, you see these complex interactions between the judiciaries of different jurisdictions. You've got the Court of Appeal asking questions of the Court of Justice of the European Union. So you start to see this really complex web of how different legal orders, about how different legal jurisdictions interact. Shortly following this case, the Data Retention Investigatory Powers Act 2014 was repealed, and it was replaced by a new Act of Parliament. So the government had another go using the Investigatory Powers Act of 2016. And so you see this sort of iterative process. It's challenged in the directive, it gets brought in through the Data Retention Investigatory Powers Act. That's ruled unlawful. The government tries again through the Investigatory Powers Act of 2016. That act has been subject to further challenge. So the Investigatory Powers Act of 2016, brought in to replace DRIP 2014, has been subject to further challenges on the basis that it breaches aspects of European Union law. And indeed, before the case that's on the screen now, the case that went back to the High Court, the government actually admitted that it probably breached aspects of European Union law based on previous rulings, and it was going to bring forward amendments. But nonetheless, the High Court again holds aspects of the IPA 2016 to be incompatible with European Union law. And then we're on to a new raft of amendments. And so what this very brief introduction to this very particular issue was meant to do was not to give you a particularly detailed understanding of the powers in DRIPA or the powers of the Data Retention Directive, or to give you a detailed analysis of the Digital Rights Island case. All it was intended to do was to make you really think about how different legal orders interact. How does the decision of one court in one legal order, sometimes in one jurisdiction, sometimes have an influence and an impact on lawmaking in another? And as I say, that's all we wanted to cover for today. So thank you very much indeed for listening. And I will see you again soon on the next podcast entry. Thank you very much indeed. Cheers.